crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome into the attorneys. Thank you so much for joining us tonight. Got a really interesting topic of conversation that will affect many of you as viewers and is really interesting. Got a good panel as well that are standing by and ready to chat. But before I hand it over to the experts, a couple of ground rules I want to remind you of all throughout the show tonight. There will be ways you can join our conversation. The show is always better the more involved you are. So you'll see at the bottom of the screen ways that you can call, text, email, and get in touch with us. And something that Hollis Wright does each and every time the attorneys is on the air is to make available attorneys who are standing by live to speak with you. That is a free, off-air and confidential conversation and a way to get some great legal advice tonight. So if you want to speak with an actual attorney, you can actually give them a call and get in touch with one. Leading our conversation tonight is Michael Eldridge from the firm. Good to see you, sir.
Good to see you, David. Good to be back.
Glad you're back. Our topic of conversation is debt collection and bankruptcy, and it really is one of those topics of conversation where boy, you hate it that it ever shows up on your door, but the advice and the information that we're going to give out tonight could be really helpful if that ever does show up.
Yeah, and I would say of legal topics that we deal with, some are more simple than others, and some, as an attorney that we studied, even if it's not our specialty, we can work through. This is one that we definitely need an actual expert, because I went to law school and I've been practicing law for over a decade now, and it confuses me every time that we talk about bankruptcy or a bankruptcy issue comes up. So excited to have someone who is an actual expert that we can parse through these questions and get through bankruptcy for our listeners and for me personally going forward. So we've got Gina McDonald here, who is a specialist in this, and good to have you on the attorneys, and thank you for being here to help us out.
Thank you. I'm glad to be here. I've been doing this for over 20 years, and that's mainly all I do is bankruptcy, Chapter 7, 13, 11s for consumers and businesses. I have offices in Jasper, Pelham, and Aniana. So I am available to talk to people and help them through these difficult times.
Well, perfect. Well, let's just start with this. For my sake, what is bankruptcy?
You know, bankruptcy is part of the federal code that says that someone can be absolved of their debts once every 8 years into Chapter 7. Chapter 7 is sometimes called straight bankruptcy or liquidation bankruptcy. People who file Chapter 7 typically don't have a lot of assets, but they may have a lot of debt. Chapter 13 is considered a wage earners plan. It's debtor's court, and that's where people pay back their debt over 5 years. Those are the two that are most of importance to consumers right now. Chapter 7, wipe the slate clean, and Chapter 13, wrap everything up and pay one payment over 5 years.
Right, so it's almost like, if I think about it this way and I have to do it in simple terms, Chapter 7 is kind of a line in the sand. We're starting completely over, and then Chapter 13, I guess, would be more, I've got some debt, I can't pay it off today, but I need a plan. And so the bankruptcy courts kind of allow for people who do have earnings to use that chapter of the bankruptcy code.
Right. You know, Chapter 7 is a line in the sand. You wipe the slate clean, you get to start over, you can do it once every 8 years. Chapter 13 is filed for various reasons. You could have had a prior 7 and you can't do another 7, so you go into 13. You could be behind on a car and the repo man's knocking at the door. Your home could be at risk of foreclosure, which a lot of people come January may be facing this. So you may want to put what's behind on that mortgage into a Chapter 13. And then sometimes people just have a sincere desire to pay their debt back. And so those are people also that would go into a 13.
Well, let's talk about that for a second, because you talk about somebody repossessing your car or a mortgage and a bank's knocking on your door and you're getting those letters. What effect, if any, does filing Chapter 13 do to those creditors? Can they still come knocking at your door and keep putting that pressure on you, or does Chapter 13 reprieve you at least temporarily for that?
Any chapter of the bankruptcy code automatically stops creditors from any kind of action against you. The way I explain it to debtors that come into my office is, you know, the automatic stay is like a bubble. And once you file that case, boom, I push the button, you go into that bubble. Those creditors cannot burst that bubble by repossession, trying to garnish your wages, suing you, even calling you without leave of the court, meaning that the court would have to give them permission via a court hearing, or that creditor would call me and say, hey, Gina, do they really want to keep this car? And if they don't want to keep the car, will they consent to me coming and picking up? But short of those two things, a creditor cannot contact you or try to use any aggression towards you after we file the case.
And I assume they're involved in the bankruptcy process as well once it's filed, those creditors?
Once the bankruptcy is filed, all the creditors are noticed out of a noticing center in Virginia. So everybody gets notice of the bankruptcy. Everyone we list gets notice of the bankruptcy. With the day that my client gets the letter in the mail saying they filed bankruptcy, 7 to 10 days, that creditor gets it. And in the meantime, a lot of times we as attorneys call those creditors and say, hey, call off the repo guy, stop the foreclosure. As a courtesy, I'll email other attorneys that are collecting on creditors' behalf and say, don't go to court tomorrow because my client has filed Chapter 7 or Chapter 13.
So one thing I always think about anytime we talk about these actions like filing for bankruptcy is, since I've been married, money comes up a lot in terms of whether it be for better or worse, as they say, in my relationship with my wife. How does it affect your spouse in terms, if you are married, do they have to be brought into the bankruptcy with you?
They do not, and that is a common question, to be honest with you, Michael. If you're married and your spouse is not on any of the debt with you, for example, you've got credit card debt, but your spouse is not on that debt, they may be on the mortgage, but if you're current on the mortgage, current on a car, they don't have to file with you. And that's a misconception that you have to file together. In fact, I try to encourage my clients that if one person can be kept out of the bankruptcy to be able to have that credit going forward because they don't really need to be in the bankruptcy. For example, maybe the wife has $3,000 or $4,000 worth of credit card debt, but the husband has $50,000. There is no need to take that bite at the apple for the wife. Let's just file for the gentleman and let the wife continue to rebuild her credit or rehabilitate her credit on her own. That way it leaves one person free of bankruptcy.
A question we've got here, will my credit be better if I go to a credit counselor rather than filing bankruptcy?
Wow, that's a hot topic for me. I have strong opinions about, they use the word credit counseling in that, but I think really and truly what they're referring to, because the code requires us to do credit counseling, so I don't want to confuse people by using that term. Debt consolidation, I think, is one of the phrases that we hear most often, and you'll see commercials on television. I see so many clients that come into my office, they've paid thousands of dollars to a debt consolidator, and they've given them all their bills. Well, maybe 70% of those bills, that debt collector or that debt consolidation company is going to be able to get that creditor to work with them. Because when you do debt consolidation, the creditors don't have to participate. They can say, oh, sorry, I don't want to participate. Discover, for example. I have clients walk into my office, they'll have a lawsuit in their hand, and they'll be, I paid $5,000 to debt consolidation, and Discover has sued me. The reason that it's not a good option, in my mind, is because you don't get federal protection. And so without that federal protection, anybody is free to sue you. And with regard to your credit's not going to get any better because you're in a debt consolidation plan, because you're not paying the full amount of the debt each month. You're not paying what the creditor requires. Right. You're paying what program they may or may not have set up for you. Mm-hmm. So I never think debt consolidation is a good plan. Debtor's court is a kind of debt consolidation, but once again, you have federal protections that keep things from remaining status quo.
Right. Let's step aside. Just need to take our first break of the evening, so we're going to take a quick break. As we do so, I want to remind you to check out Hollis Wright on social media, wherever you are, whether it be Facebook, Twitter, Instagram, YouTube, wherever you are, they are. Check them out. A great educational, informational resource. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the attorneys.
Welcome back into the attorneys. Appreciate you being with us tonight. About to return to our conversation, but before we do so, I want to remind you, take advantage of that opportunity to speak with attorneys who are standing by live from Hollis, Wright. They're available all show tonight. That free, off-air, and confidential conversation, it is yours for the taking. A question we've got here: how do I know if I should choose Chapter 13 over Chapter 7 when it comes to bankruptcy?
That's a question I answer every day, and that's my job, is to make that analysis for a client. One of the most common problems with someone filing a Chapter 7 now, since the code changed in 2005, is income. There are a lot of clients who make too much money, especially where my office is located in Pelham. I have a higher income level of clients, so therefore, if they make over a certain amount of money per how many people are in their home, they can't file a Chapter 7. Congress changed it so that they're forced into a 13. So that's the number one reason that I would put somebody in a 13 and recommend a 13, is if they make too much money.
All right.
A second reason would be is if there is a car that they want to save, that would be a reason. If you're 4 or 5 months behind on a car note, then if a Chapter 7 is not going to work for you, because as soon as I file a Chapter 7 for you, that creditor is going to be filing something with the court saying I want the car back. So putting a car into Chapter 13 is a reason for filing 13. Mortgage arrearages. Like I said before, we're going to have people with a lot of mortgage arrearages coming up. You want to avoid foreclosure, put your mortgage arrearages into a Chapter 13. Another reason is if somebody just really has a desire to pay their debt back. And there are a lot of people out there that say, I know I qualify for a 7, Gina, but I would really rather file a 13 and pay my debt back. Those are the main reasons when I look at someone and I do an analysis is, are they going to lose something? Are they going to lose a car or their home?
Right.
Do they want to pay their debt back? And in some cases, they filed a Chapter 7 before, so therefore they're forced into a 13.
Well, one of the things I think about, or I was thinking about when you were talking about 13 or 7 and what the debtors do, a lot of my clients, and most of what I do is personal injury work, but after they sign up, their question is, all right, now what happens? So what is kind of the timeline and the process of, all right, we've decided we're going to file Chapter 13 bankruptcy, now what?
A Chapter 13 bankruptcy, once they consult with me or some attorney and we make the decision to move forward, the first thing that a client has to do is to provide me with information. There's a lot of information. I'm not even going to go through the list. They can check my website for that. They provide me with a lot of information. We have to have credit counseling done, which is an independent agency, which basically, we give them a book, they read it, we get a certificate. We have to have those things done. We pull a credit report. We file the case. As soon as we file the case, they're in a plan of reorganization. And we tell the court what we propose that they pay each month and where the money goes. So after that, there's one court appearance. It's called a 341 meeting of the creditors. That's where any creditors that have any questions can show up. Very rarely do creditors show up, maybe some credit unions locally. The second court appearance is called confirmation, and the timing of that is 30 days for the 341 meeting of the creditor and about two and a half months on the confirmation. Confirmation is a fancy word for saying the judge has blessed your plan, the trustee who manages your case has blessed your plan, and you go forward and you continue to make your plan for up to 5 years usually. A little bit different for Chapter 7. Chapter 7 is very quick, fast-paced. Same thing, we get credit counseling, we gather the documents, they pay the attorney fees up front, and then we file the case. between about 30 days, you're in front of a trustee, and that trustee is deciding whether or not you're going to have an asset case or a no asset case. 99% of my cases are asset cases. That means that they don't have a property that's too much equity in it or too much personal property. At that 341 meeting of the creditors can show up. 60 days from that date, the discharge is entered. So we're talking roughly 3 to 4 months, and that is over for you, and you're debt-free and move on down the road.
60 days sounds like a long time to some, but in my world, that's a quick turnaround.
It goes by quick.
Do you have, obviously you talked about the protections you have from your debtors once you get into this bankruptcy bubble. What about in terms of your employment? You know, obviously people have different employments where their assets may matter, or a bankruptcy could affect their employment. Do those federal protections apply in those situations?
There is a code section, I believe it's section 525, and I've always been told since I practice law, never spew a number out, but I believe it's code section 525 that says an employer cannot terminate you because you filed bankruptcy. And I have a lot of people who are in banking, who are in securities, who work for Homeland Security, and they're always worried, in the military, they're worried about their security clearances or their licenses for different things. What I tell them is, if your employer wants to fire you, they're going to find another reason to fire you, and they're never going to say it's bankruptcy, because if it's bankruptcy, you're going to make a lot of money off of that case.
Right. Yeah, call me at that point.
That's right,
Perfect.
exactly.
One thing I've heard about is someone files Chapter 13 and it gets converted into a Chapter 7. Who makes that decision? If you said, hey, I want to file a Chapter 13 or I want to file a Chapter 7, and that, no, we're not going to do this, we have to go a different route.
Right. For the most part, it's the client, with attorney counsel, obviously. There are times when people go into a 13 with all good intentions. They have a great job, they're paying their debt back, but let's say their income drops by 50% and they can't afford to fund a Chapter 13 any longer. We would convert that case to a Chapter 7 more than likely. There are also times where it's a strategic move to put them in a 13 to get maybe the car caught up and then convert to a Chapter 7 so that they're current on the car when they go into a 7, but all the junk debt goes away. It's never a decision that we make. There are some times when the court will suggest that a client be converted from a 13 to a 7, but more than likely the client has that final decision making.
When we talked about the Chapter 7, we kind of described it, or I think I did, so I shouldn't speak for you, but it's a line in the sand, and it's a quick process. It's a complete bankruptcy or a complete dissolution. Are there any debts that remain or survive a Chapter 7 bankruptcy?
There are debts that remain in a Chapter 7. If you owe any sort of child support, it remains. If you had an arrearage on child support and you filed a 7, you're still going to pay that. If you had a debt that was incurred, there's different types, but if you had, say you did credit card charges, you went to Disney World 90 days before and ran up $800, $900. Anything over $750 to one creditor in a 9-day period is usually not going to be dischargeable. Now the creditor has to reach out to you and say, Gina, your client did this, what are you going to do about it? Also cash advances in 70 days over $1,000 typically are not dischargeable. Taxes, for the most part, are not dischargeable. Now there is a loophole in the law, it's not really a loophole, it's written into the law that some taxes can be discharged. I've been very successful maneuvering the system and getting taxes discharged for a lot of my clients. It's something separate of the bankruptcy, but it's within the bankruptcy. And I've gotten up to $400,000 worth of tax debt discharged for a client before. Good. But it's very tricky, it's very complicated. You certainly need an attorney to talk to about that. Other debts that might not be discharged in a 7, I'm sorry about that, David, would be debts that you failed to list. Okay. Or lawsuits that you maybe say you got a DUI. And it's because of your negligent. If there's a lawsuit pending out there and you owe somebody, then that debt more than likely will not be discharged.
Let's step aside right there. We got to take our final break of the evening. This is it. So the final break coming up right here. We're going to come back real quick and wrap things up and continue our conversation. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright. In court, attorneys are not allowed to tell juries certain things. For example, we cannot talk about a defendant's net worth, meaning the defendant's ability, resources, or insurance to pay a verdict. In this week's Legal 4-in-1, we're answering the question, why can't lawyers talk about a defendant's net worth to a jury? Now, Rule 403 of the Alabama Rules of Evidence states, in part, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice. Long-standing Alabama cases have held that the net worth of a defendant falls under this catch-all rule and is to be excluded. The reasoning behind the rule is that if a jury knows a defendant is wealthy, then the jury might award more money to the plaintiff. And this goes one step further. If an attorney makes any remarks that suggest the defendant is responsible because he is wealthy or rich and the plaintiff is poor, that can be grounds for a new trial. If you're ever on a jury, the reality in our state is this. In almost every lawsuit that goes to trial, the attorneys representing both the plaintiff and the defendant have already looked at whether there's sufficient insurance coverage or assets to satisfy a verdict. Most likely, the parties would not pursue a civil lawsuit if damages could not be paid after a jury returns a verdict. So even though lawyers cannot mention the net worth of a defendant during trial, there likely are resources available to pay a verdict in court. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. And remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. And as always, thanks for watching The Attorneys right here on WBTN 13.
Welcome back into The Attorneys. Thanks for being with us. About 6 minutes remaining in this show. So again, if you want to take advantage of the opportunity to speak with attorneys from Hollis Wright, got about 6 minutes to do so. Michael?
Yeah, so we just talked about what debts remain after you file a Chapter 7, which it was a limited amount, but there are some that could apply. Right. What about Chapter 13? Are there any debts that remain after that, or what would those look like?
The debts that would remain after Chapter 13, typically it was what we see as student loan debt. That's also non-dischargeable in 7.
Dang.
Yeah, I know. So if you file, student loan debt has to be listed for the most part, unless it's in forbearance or in deferment. But as you're paying your debtor's court case in those 5 years, the interest is still accumulating. And more than likely, we're not paying enough back to have it paid off in 5 years. So I always warn clients to be aware that at the end of the discharge, when your Chapter 13 is over, look for some student loan debt to have to be paid off.
How many times can you do this?
Oh, wow. You can do a 7 once every 8 years. And so I've been doing this long enough, and at one point it was 6 years. I've been doing this long enough that I've had clients file 7 with me 3 times now. 13, you can do it every 5 years, basically, just roll into a new case if you had to. Normally people don't have to do 13 that often, but 7, you can do it once every 8 years. And believe it or not, I have clients waiting for that deadline so that they can file again.
And do you get treated differently the more times you file it, or is it the code treats everyone the same?
As far as a 7, you don't get treated differently. If you're in a 13 and you've gotten a case dismissed several times and not completed, you would get treated as a habitual filer, and there might be some more rules and regulations that you have to follow. For example, you may have to do payroll deduction. We may have to file a special motion so that that bubble of protection will ensure that you get protected throughout the life of the case. But that's about it.
In terms of when you're in your bankruptcy, do you have a credit at that point? Could you go get another loan?
Not in a 13. In a 13, you can in a 13, let me rephrase that. You have to get permission of the courts to take on any new debt in a Chapter 13. Now in a Chapter 7, once you file the case, there are creditors, there are car lenders that send letters for my clients in Chapter 7s all the time. Let's get you a new car. Why? Because they know you're going to have to pay that debt for the next 8 years, or they're going to get a judgment against you if you don't pay for it. But in a 13, you have to get permission of the court to do a lot of things.
And that's like if you wanted to go get a home loan or a mortgage or a car payment, just like that.
If you want anything like that, even if you want to sell your home, if you're in a 13, you have to get permission of the court.
Okay, as long as you are in the duration of that Chapter 13 plan, the court's going to decide whether or not you're going to sell assets or you're going to take on new loans.
They're the boss. That's right.
Understood.
Let me ask you, you're talking about folks who file multiple bankruptcies. Every election, if anybody's filed bankruptcy, it comes up and they file bankruptcy like it's a bad thing.
Right.
As someone who sees this all the time, do you think folks who've gone through bankruptcy are kind of mistreated in some form or way, or there's is treated worse than they should be?
There's a stigma, I believe, but I think it's a self-attaching stigma that people, because I'm in my mid-50s, and my parents, the people down the street, filed bankruptcy. That people around us didn't file bankruptcy. Now it's much more common. If people come into me, it's for a moral or religious or a stigma type reason. I don't think anybody's treated any differently as far as mortgages. When you go back out and you're on your feet again, you can get a mortgage. Like I said, you can get a car loan. I think the stigma is created within someone's mind.
Really?
Mm-hmm.
Yeah.
And the game Monopoly did not help.
It did not.
That's true.
That's for sure. Yeah.
You never want to go bankrupt in Monopoly.
Hey, let me ask you real quick. We've got about 30 seconds before I want to get to y'all's final thoughts. But do you advise folks to come to you before the wolf is at the door and things are like in chaos? Because if things are trending and it doesn't look good, it seems like if you're proactive about that, it seems like you could probably help folks either avoid or maybe plot the way forward. And I think it would give folks a lot more ease and calm about what's ahead.
Right. I always prefer a client that comes to me well before the creditors are knocking at the door. In a lot of cases, I can help settle debts, and we won't even have to file bankruptcy.
Right.
If they're in a pre-suit situation, I can negotiate with a creditor and maybe never file bankruptcy for that client. But if it does lead to a client, at least I can give them advice moving forward about how they should be allotting their income and what debts they should be paying and not paying.
Yeah, I'm sure so. All right, less than 2 minutes remaining. I want to give both of you a chance for a final thought. And if you would, you go first, please.
My final thought is the only attorney most people see, in my opinion, is a divorce attorney and a bankruptcy attorney. Very rarely, we don't have just thousands and thousands of personal injury cases that walk in our door. So a lot of times, the only attorney that someone has ever met is me. Right. And so there's a lot of bad thoughts about attorneys. And so I think that what clients need to understand is that we're all great people, we're all great attorneys, and we just want to help you and we want to give you advice. So don't be afraid to come see an attorney. Yeah. That's what we're trained for. We want to help people, or we wouldn't be doing this line of work.
That's good.
That's
Michael?
my final thought.
That's good.
Well, what I would say is that obviously this area of the law is highly specialized, and there are people out there that they're getting these letters over and over again, and they have these, like you said, wolves at the door, and they don't know what to do. And it doesn't hurt to ask someone who is an expert in that field to determine whether or not you need to go this route, and then to understand, like we learned today, that you get these federal protections, right? That you get in that bubble and those wolves can't get in, and now that they are subject to the bankruptcy code. So don't be afraid to ask to figure out if that's the smart route for you.
Yeah, good advice and a really good show. Appreciate both of you being with us. Thanks so much for the time.
Thank you, sir.
Thank you, and we appreciate you all being with us, and we appreciate you being with us as well each and every week. We really are grateful for the time you spend with us and meeting us here each and every Sunday night. I hope it's been beneficial. Again, thanks for being with us, and we'll look for you next time. We'll do it all again next week. Another interesting topic and another interesting lineup of guests, so we look forward to seeing you then. Thanks so much, and we'll see you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.